The decade of 1840s witnessed significant changes. 1843, annexation of Sindh. 1849, annexation of Punjab. Doctrine of lapse implemented by Lord Dalhousie. Annexation of Lower Burma. So new territories were being incorporated into the Indian Empire. So while new territories were being incorporated, the previous system of 3 presidencies had to be adjusted along with this. There was a growing opinion in England that this double government of one aspect with court of directors, other with board of control must be done away with. Now the empire in India had become more confident, had become more potent. Therefore, there was a clamor, there was an opinion in the British Parliament that sooner or later this double form of government must be done away with. But then there were sympathizers of the company, and there were those who were now indoctrinated or who were now looking forward with the spirit of British nationalism of extending the Crown's direct rule in India. The British Parliament at this point of time did a balancing act. With respect to the Court of Directors, the number of directors in the Court of Directors were 24. So what the Charter Act of 1853 did, with respect to the Court of Directors, their numbers were reduced from 24 to 18. Now here also 6 were to be nominated by Parliament or were to be appointed by the Parliament. So effectively, the strength of the Court of Directors were reduced. Secondly, we have seen that the Court of Directors, they had the power of patronage. What do we mean by power of patronage? It means that officials in India, whether it is Governor General, governors, they were all appointed by the Court of Directors. This power of patronage was withdrawn. And instead of this, an open competitive examinations. These were introduced. We have seen in the Charter Act of 1833 that section 87, it stated that no individual shall be disqualified solely on the basis of religion, color, race, descent, place of birth in occupying the highest office. But the Charter Act of 1833 had not laid down any procedure for appointment to the highest offices. But Charter Act of 1853, falling in line with section 87 of the Charter Act of 1833, it stated open civil services examinations, for which Lord Macaulay was made the head in 1854, to develop a scheme of an examination where nobody would be disqualified solely on the basis of merit. Highest position in the overall administration would be occupied. So the Court of Directors over here, it lost miserably with respect to power of patronage. Number of members as 6 were to be nominated by the Crown. However, because British Parliament, it did a balancing act, it did not set aside or it did not ignore Court of Directors or East India Company entirely. The East India Company was allowed to continue. The East India Company was allowed to administer territories in India, but this time there was no specified time limit mentioned. So the company was to function in India in trust of Her Majesty, heirs and successors. So there was no time limit specified. In continuing the charter. So we see the company was allowed to exist, but till what time it will exist, it was not mentioned. The company existed in trust of Her Majesty, her heirs and successors. The number of directors were reduced from 24 to 18, and even within 18, 6 were to be from the British Parliament. In fact, prior to Charter Act of 1853, there was a growing demand amongst the presidencies. The presidencies claimed that there should be a Secretary of State with a council which must replace this double government at home. So the double government continued to exist, but we see that the Court of Directors, their power had been considerably reduced. But this Charter Act of 1853 is known for separation of executive and legislature. This is a very important development. In fact, if I were to trace the history of Parliament of India, I would trace it to Charter Act of 1853. Because as per the Charter Act of 1833, there was a Governor General, and he had 3 councillors. There was a 4th member who was the law member. He was introduced as per the Charter Act of 1833. So effectively, the Governor General and his council was the Governor General and the 3 councillors, and the 4th law member, he was allowed to attend the meeting, but he was not the member of the Governor General in council. But what the Charter Act of 1853 did, the Charter Act of 1853 now made the law member a full-fledged member of the Governor General in Council. So as per the Charter Act of 1853, now the Governor General and 4 members, including the law member, they formed the Governor General in Council, or this is called as the Executive Council. The Executive Council which executed the policies. Charter Act of 1853 now created a Legislative Council as well. See, Governor General Executive Council already existed. Charter Act of 1853 included the law member in the Governor General Executive Council. Now the Charter Act of 1853 included 6 additional members. And who were these 6 additional members? One was to be the Chief Justice of Supreme Court at Calcutta, plus one was to be a puisne judge of Calcutta Supreme Court, one representative of Bengal, representative of Madras Presidency, representative of Bombay Presidency, and one was representative of northwestern provinces. So effectively, there were 6 additional members who together formed the Legislative Council. So when we talk about Governor General in Council, the Executive Council will comprise of Governor General and the 4 members, and Governor General and 10 members, they were the Legislative Council. So a separation was created between Legislative Council and Executive Council. What had happened was, prior to Charter Act of 1853, the Governor General of India was also Governor General of Bengal. So the Madras Presidency, Bombay Presidency, they used to complain that he is biased. He would be more biased towards Bengal. And therefore, the Governor General in the Charter Act of 1853 was separated from the Governor of Bengal. And when the Legislative Council was created, it had a provision for separate representative of Bengal Presidency. There was a representative of Madras Presidency, representative of Bombay, and representative of northwestern provinces. So the Charter Act of 1853 is notable for separating executive with legislature. But was this legislature indeed effective? No. Because the legislature, it could discuss whatever is the policy resolution by the executive. It could introduce a bill, but executive could always veto whatever is the bill introduced by the council. And one of the major defects of this council was there was no Indian representation here. The very subjects on whom the British were ruling, was it represented? No. Therefore, the Charter Act of 1853, although it had the novel provision of separating executive with judiciary, it was not effective enough. We have seen that there was annexation of territories. Sindh was annexed, Punjab was annexed, there was Lower Burma. Then further, there was annexation of Satara, annexation of Nagpur, there was annexation of Sambalpur by Lord Dalhousie, there was annexation of Jaipur, there was annexation of Jhansi, there was annexation of Berar, there was annexation of Awadh. So we see that new territories were being annexed and they were to be incorporated into the empire. So over here, the court of directors, they were given a free hand. They could alter the boundaries of existing presidencies, or they could create new presidencies. Accordingly, a new presidency of Punjab, a new province of Punjab would come into effect. So we see Charter Act of 1853 was indeed a balancing act, where the court of directors, their power was reduced, so the company was allowed to exist, but its power was reduced considerably. In fact, it was a matter of time when the British Parliament or the British Crown would directly claim sovereignty over Indian territorial possessions. And this opportunity was provided by the rebellion of 1857, the revolt of 1857.